Good morning. We are on record following a conference between the attorneys as well as a bench conference for a pretrial in this case. And we were scheduled for a review, but I'll let Ms. Hanson-Grimes formally put her request for adjournment on the record after appearances.
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel with the department. Present is also Ms. Jamie Fries, who was the CPS investigator, and Mr. Christopher Farian, who is the ongoing CPS worker. Can you both state your name for the record?
Jamie Fries from the department.
Christopher Farian for the department.
Attorney Ashley Hanson-Grimes on behalf of Father Michael Mulholland. I believe he is joining us via Zoom, Your Honor.
Okay, Mr. Mulholland, if you can hear us, please give us your name for the record, please.
Michael Mulholland.
All right, we have another participant logged in under a Samsung phone. Would you like to give us your name, please?
Melanie Mulholland.
Thank you. Welcome. All right, Ms. Hanson-Grimes.
Yes, Your Honor. I was recently retained by Mr. Mulholland as in this week. And given that it's only Tuesday, it was rather late to give notice to the court. However, I have authored a substitution of attorney. I have spoken to his previous attorney, the Public Defender's Office, and Mr. Michael McFarland, and he has agreed to substitute me in as the new attorney for Mr. Michael Mulholland. Given those facts, I would like, and given how new this case is, as we're about 90 days since it was opened, I would like to request that within the confines of the juvenile law, that we be able to have a review as the children are placed with their mother in a 6-month time, which would give us till December to review this case and review the progress of the children. I had stated to the department my request and that I plan on filing certain motions that can be heard outside the confines of a review, but also will need further investigation before we put them in front of Your Honor. So at this time, we would waive any timeframes as it relates to when the trial can be held, and we ask to secure a jury trial date after the first of the year to allow the criminal case to move forward, but to also allow for appropriate motions to be in resolution to be sought in this case. I don't think that I have any opposition at this time to this request. However, I will ask you to confer that with my fellow counsel.
Okay, Ms. Thomas.
Thank you, Judge. I do agree with Ms. Hanson-Grimes' resuscitation of the facts. And I also want to just put on the record that I had failed to meet my own time requirements for filing things such as the notice of intent to use child hearsay statements. We have also not filed our witness and exhibit list, so we were behind the ball, and we definitely would join her request in the adjournment. Thank you.
Ms. Heiss.
Thank you, Your Honor. I have visited with the children in person, and they are placed with their mother. All of their needs are being met in the current placement. The time frame suggested by defense counsel, I think it would not cause any prejudice to the children. So I join in asking for those new dates. Excuse me.
All right, thank you. I will also say that we discussed the fact that the 6 months is the requirement for purposes of trial. Right now, we have the jury trial scheduled for October 18th and 19th. The dates that we've secured to reschedule that to include enough time for potentially 3 expert witnesses is February 12th, 13th, and 14th, 2024, commencing at 9 a.m. Today will be documented as a pretrial, but the review portion, I think we're gonna move over to December to allow Ms. Hanson-Grimes to have a look at the exhibits more in depth before she's ready to potentially cross-examine Mr. Farian, if you will, on those documents, and to look at the issue of parenting time again for the older child. there are, as I understand it, bond conditions preventing Mr. Mulholland at this time from parenting time with his daughter. And that is further supported by one of the exhibits that was provided today. But parenting time for this parent and his son is not definitively prohibited by the child's therapist. However, the therapist has effectively simply declined to offer an opinion on that at this time. Given the allegations in the petition and that obviously these two children are siblings, I would ask the department to seek further expert opinion on duration, frequency, and whether or not it's in the interest of Mr. Mulholland's son to spend some time with him. We've discussed the fact that both children appear to be missing their father, and that clearly the absence and the break in the familial relationship is affecting them. We are at pretrial stage. I don't have jurisdiction at this juncture to really be able to address that definitively, but it's appropriate to, the court finds it's appropriate to ask the department to continue considering what that looks like for Mr. Mulholland and his son. But even if I were to try to authorize parenting time for him and his daughter right now, there are bond conditions that prohibit that. Is that right, Ms. Hanson-Grimes?
It is my understanding that there is bond conditions regarding my client and minor children as a whole. And so I would seek to have his attorney on the criminal matter address those before I make an ask of this court. That certainly could not be fulfilled.
Thank you. All right, so our order will continue to prohibit parenting time, but also obviously it's prohibited in the other case for the time being. And if you want to file a motion on that to be heard at the same time with our review on December 12th at 10 a.m., that would be when I would ask you to maybe address that.
Your Honor, with the court's permission, if I am able to work with fellow counsel to relax those bond conditions in order to participate, I would like to file that ahead of time, whether that's via stipulation, whether for an evaluation to occur as to what parenting time could look like, or if it would be appropriate. So I don't want to wait till December for that, if we can kind of move through the other restrictions.
I will be ordering today. They have additional evaluation for recommendations on parenting time. So if that comes back and you understand that that is recommended for them, you can feel free to file a motion if it's not back before it's time to do that in December.
The problem right now is what I foresee is if we don't work with the circuit court bond conditions, that my client wouldn't be able to participate in those evaluations. And that is what one of the letters requested. And so that's what I'm seeking leave to, I guess, authorize once the department, if they would confirm with me who they're thinking to be the evaluator, and if those bond conditions can be relaxed, then I would like my client to be able to participate in something that you have ordered. But as of today, as of a snapshot in time today, we couldn't do that. And I don't want to set him up to fail or to create work for the department that isn't something that we're able to see through.
The suspension of parenting time would not extend to prohibit him if it were authorized in the circuit court case as well. Obviously, I have no control of that,
Right.
but if that's, in my opinion, the suspension of parenting time would not prohibit him from participating in an evaluation on parenting time if the parenting time evaluator wants him to be part of
Okay, thank you, Your Honor.
it. Any questions on that point?
No, Your Honor. Thank you.
All right. I would note for the record that one of the exhibits that we received today does appear to respond to one of the outstanding concerns that we've had in this case, which is that your client, Ms. Hanson-Grimes, said indicate he may potentially have some Native American heritage. It looks like we did get some responses back on that, indicating that there is no Native American heritage, but if you could make sure you follow up with that as it relates to your client and Mr. Farian, to make sure that, you know, if he does have eligibility and those resources are available to the family, that he's able to take advantage of this.
I certainly will. Thank you.
All right. Would you like to take some testimony from your client as it relates to the waiver on the timeframes, given the dates?
Yes, Your Honor.
Okay, Names, please swear in Mr. Michael Mulholland.
Mr. Mulholland, can you hear me, sir?
Yes.
I can't see you, so can you raise your right hand, please, and let me know when it's raised?
It's raised.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Mr. Mulholland. You had previously heard me indicate that we would waive any timeframes that we are eligible for under the statute as it relates to having a trial in this matter within 6 months of the date of the initiation of the petition. Did you hear that earlier?
Yes, ma'am.
Okay, and do you agree with that waiver? Although you do have a right to have a jury trial within those 6 months, that you are waiving that right in order to facilitate some other things that are going on right now.
Yes, ma'am.
Okay, and so you have no problem with the court writing that in its order today that those timeframes are waived and to continue to jury trial in February regarding this matter?
Yes, ma'am.
Okay, thank you. I have no further questions, Your Honor.
All right, thank you. Ms. Thomas, Ms. Heist, are you satisfied with the waiver based on the testimony of Mr. Mulholland?
I am,
Yes,
Your
Your
Honor.
Honor.
Thank you, ladies. All right, very good. I'm happy to sign an order releasing that video so that you can have a look at that and schedule any other motions and tender years as requested once those things are filed. Is there anything else that I can address for you or for the family this morning, ladies and gentlemen?
No, Your
Not
Honor.
at this.
All right, well, the court finds it does serve the interest of the children to allow for the adjournment. Also the interest of the parents, so that Ms. Haynes Grimes can familiarize herself with the facts and circumstances of the case and the court report and exhibits that were prepared for today, as well as to have time to release and examine the video from the CTAC interview and all our CAC interview, sorry. And probably allow the parties to prepare for trial. But we would ask you to try to have your witness and exhibit list ready for exchanged, filed on or before our last retrial date in December. As it relates to the jury instructions, what are your questions, the jury verdict form? We can set that for file and exchange no later than 2 weeks prior to trial, if that works for you.
It does, Your Honor.
Yes.
All right, I'll put that in the order as well. Unless there's any questions, that's all for today, and we'll see you December 12th at 10 a.m.
One further ask, Your Honor. May I have the CV or resume of any exhibits put forth of a professional witness by the department? And I will provide the same.
Absolutely.
Okay,
Thank you, Your Honor.
very good. Thank you.